Hello there, my name is Dan Perry and I'm an estate planning attorney with Thomas Walters Law here in Tennessee, and I have offices here in Franklin as well as in Murfreesboro and Knoxville, and I really service clients, our firm service clients all throughout Tennessee. But what I want to talk about today is how to prevent family disagreements when it comes to your will and trust. Now, really and realistically, the most important way and best way to do this and to avoid these types of family disagreements is to simply hold a family meeting where everyone sits down and it's explained what's going to happen when you and your spouse pass away, how things are going to go, and that they understand your wishes and your goals and what you want to accomplish and why you structured things in this way, such as why you're giving John only 30% while you're giving Susie 60%. And in my experience, when families are involved in the estate planning process in this manner, the chances of disagreements after death are reduced substantially. However, sometimes disagreements just can't be avoided, and these disagreements with family members can sometimes go into court as a result. And when these situations seem like they're a possibility to occur, what I usually recommend for my clients is that we utilize what's called an interim clause, commonly called a no contest clause, in their will or trust. And what this does is that it provides that should any beneficiary of the will and trust decide to contest the action by filing a legal action in the court, well, this clause states specifically that should that beneficiary choose to do this, that beneficiary would not be able to share in the estate, and their share would go back into the pot to be divided among the remaining beneficiaries of the estate. For example, let's say John and Jane put an interim clause in their trust because they were worried about John Jr. Now let's say both John and Jane are gone, and John Jr. decides to contest the trust, and he's not successful. Well, the interim clause would then provide that John's 1/3 share would go back into the pot, and John's two younger siblings would each get 50% of the entire estate. John Jr. is left with nothing. And this type of planning usually reduces the possibility of any legal contest occurring against the estate. Now, if you have more questions about interim clauses, no contest clauses, wills, trusts, powers of attorney, estate planning in general, please click the link below. It'll take you to a contact form where you can schedule a time to come in the office and visit with me, complimentary initial consultation, where we'll discuss your estate planning needs and concerns and what you want to accomplish. Also, there are many free videos here on the website you can watch yourself. You can also go ahead and request some free legal reports that I have drafted and written myself on various estate planning topics that could help you along your estate planning path. Also, I invite you to attend one of our live free educational events. We hold them every month at a variety of different places here in Nashville as well as out in Knoxville. And come in and start to learn about all the estate planning issues and concerns and what you can do to protect your assets while you're alive, provide that smooth transition to your loved ones when you're gone. I want to thank you for tuning in today, and I hope you have a great day.